Can the executive branch ignore a ruling from the judicial branch? To find out, you have to read Ex Parte Merryman, but it's 20 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where normally I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. But this is part of a special limited series I'm doing on cases that are landmark cases before the United States Supreme Court that are relevant to today's world. This is the case of Ex Parte Merryman, and the issue in this case is broadly whether the executive branch is allowed to ignore or non-acquiesce to the judicial branch's orders, or specifically it's about whether the executive branch is allowed to suspend the writ of habeas corpus, ignore a judge's order with respect to a writ of habeas corpus. To understand and appreciate the context of this case, you have to know that a writ of habeas corpus is an order by a judge with respect to a person who's been held in custody by the executive branch. It's 1,000 years old or so. The writ of habeas corpus is called the Great Writ in England and in early America. And essentially, it's an order signed by a judge saying to a party that's holding someone in detention, bring the body, habeas corpus, bring me the body to court and explain why you're holding this person in custody. Perhaps there's criminal charges, perhaps there's a warrant of arrest, perhaps there's a good explanation. It's not just that a person gets brought by a writ of habeas corpus and they're released, but the question is, why are you being held? Because the claim that brings a writ of habeas corpus is that I'm being held illegally, unconstitutionally, against my will. So you can issue a writ of habeas corpus for someone being locked in a basement, but usually it's for a sheriff or a warden to bring someone to court because they're being held illegally, is the claim. And then the sheriff or warden comes and says, this is why I'm holding them. Okay. So that's the background that's helpful here. And the writ of habeas corpus is located at Article 1, Section 2, Clause 9 of the United States Constitution. Article 1, of course, being the section that deals with the legislative branch. Okay. So what are the facts in this case? The facts are that in 1861, right, the United States Civil War is breaking out, and the chief executive officer, who is President Abraham Lincoln, suspends the writ of habeas corpus while Congress is in recess. And he basically says, I'm suspending the writ of he issues an order saying I'm suspending the writ of habeas corpus, and I'm delegating my authority to my military, to the officers of the United States Army, they can arrest people without a warrant, without bringing them to a judge. They can grab them and put them in military holding cells. And so that's what happens in this case. So this person by the name of Merryman, he's arrested by military officers for allegedly blowing up railroad bridges, because Maryland doesn't want to cooperate with transporting Union soldiers to Washington, D.C. And so he's arrested for treason and for blowing up bridges. And he gets brought to Fort McHenry, which is in Baltimore Harbor. He somehow gets a letter out, or a request to the United States Supreme Court to issue a writ of habeas corpus. And the chief judge of the United States, Judge Taney, Roger Taney, United States Supreme Court chief judge, issues a writ of habeas corpus. He goes down to Baltimore, to Maryland, because back in those days, the judges of the Supreme Court were actually circuit court judges also. And he says, bring me the body. He issues a writ of habeas corpus to the General Cadwalader, who is the head of Fort McHenry. Bring me the body. And instead of bringing the body, a major comes to court and says, well, I'm here sent by the general. I'm not going to I didn't have the body. And I'm telling you that I brought him here because Abraham Lincoln suspended the writ of habeas corpus. And Chief Judge Taney says, that's not what I asked. I said, bring me the body. He's in contempt. So he issues a contempt citation to Cadwalader and sends a U.S. Marshal to go deliver the citation to say, now you got to come see me because you didn't do what I ordered. And when the U.S. Marshal goes to the gates of Fort McHenry and says, I'm here to deliver a warrant of attachment to grab the general and bring him with me, they don't let him in the fort. And he comes back, the marshal comes back and reports this to the judge, and the judge has to now figure out what to do with this. And he issues this order, which is famous now, this decision of Ex Parte Merryman, which essentially says, I issued this order it was not complied with by the executive branch. The holding here is, I don't have an army. Normally, I can call up a posse comitatus, which is a group of people from the county, to go grab a person who's being lawless. But I will lose. This is a military. I can't send the marshal and 12 people to go take on the United States military. They will lose. So instead, he writes this decision and sends it to Abraham Lincoln and says, you are acting beyond the scope of your authority. The privilege against suspending the suspension clause, the privilege against suspending the writ of habeas corpus is constitutional. It's in the Constitution. So you're not allowed to do it. And the only branch of government that can do it is the legislative branch. And you are not the legislative branch. You are usurping your authority. But I can't do anything beyond rebuke you in this decision. I don't have my own army. So I'm going to send this to the President of the United States and hope that somewhere along the line there was a miscommunication and you rescind what you have done here because you're acting beyond your authority. And that's essentially the holding of Ex Parte Merryman. It's unclear whether the Chief Judge of the United States, this is not a Supreme Court decision. It's a decision by the Chief Judge of the Supreme Court in the Circuit Court of Maryland. But essentially the holding here and the importance of this case is that it introduces the concept of non-acquiescence when a constitutional crisis erupts because the executive branch refuses to comply with what the judicial branch has done. And there's no answer, according to the decision of Ex Parte Merryman. There's no way to force the executive branch to comply. And it's lamented by Chief Judge Taney. And that's the case of Ex Parte Merryman. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.